Richard, please make sure that you're unmuted and that your screen is off for now. Thank you.
Good afternoon, colleagues. It's 3 o'clock and we're going to get going straight away because we've got a lot of content to work through today and we want to have as much time as possible to engage with you. So I welcome you on behalf of the organizers. I'm representing today the Navi Pillay Research Group at the UKZN School of Law and our co-organizer, the School of Law at the University of Pretoria. You are most welcome to this colloquium on the Promotion and Protection of Persons with Disabilities Bill. My name is Janine Hicks. I'm a senior lecturer here at the School of Law at UKZN and a convener of the Navi Pillay Research Group. So a word about the famous Navi Pillay. Dr. Pillay is one of ours. She's a UKZ alumna. Her work, though, needs little introduction. We are all, I'm sure, familiar with her work as an activist practitioner under the apartheid era in South Africa, working to address and seek redress for the rights of those subjugated under the apartheid system. But more recently, she chaired the International Criminal Court's International Criminal Tribunal for Rwanda in addressing and responding to crimes against humanity and genocide. Equally, though, she was served as the United Nations High Commissioner for Human Rights, and importantly and significantly there, she developed for us a normative framework on international justice. One of her key legacies that she left was on practices and protocols on addressing gender-based crimes, such as rape in war times and having that recognized as a war crime. She's still active and working amongst us. She's currently serving at the behest of the UN Human Rights Council. She's the chairperson of the UN Independent International Commission of Inquiry, which was established to investigate Israel's occupation of Palestinian territory, as well as historic and recent acts in violation of international and humanitarian law. So in honor of Dr. Pillay, the Navi Pillay Research Group was established at the School of Law, both to honor her legacy and her agency, but also to draw on her relentless energy and engagement and create a platform for us academics within the School of Law to undertake critical research and policy advocacy in the social justice sector. And this is where our work in the realm of disability and disability rights protections is anchored. Our intention as the Navi Pillay Research Group is to establish this collaborative entity, an interdisciplinary entity that can support both research and education interventions, but also policy and advocacy responses on contemporary social issues of our time. These pertain to race, to class, to gender, disability. The kinds of issues that we've been engaged in recently has been supporting and lending research support and dialogue space to the work of the UN Commission of Inquiry in relation to its findings against Israel's unlawful occupation of Palestinian territories and the emerging and ongoing acts of genocide against residents of the Gaza Strip. But we've been active as well in the land reform and traditional land ownership and the Ngonyama Trust space. We've been active in seeking accountability under international law for apartheid-era atrocities. But equally at the local level, we're responding to persistent forms of discrimination and human rights violations, particularly those impacting on vulnerable categories of people, homeless communities, informal settlement residents, and people with disabilities. So it is in pursuit of our desire to engage with policy advocacy in these spaces pertaining to the rights of people with disabilities that the NPRG and the UP School of Law, the University of Pretoria's Law School, has a phenomenal track record in its disability research. And academics from our two schools of law have therefore shared their concerns at the inadequate exposure, in our view, that has been accorded to the bill on the promotion and protection of persons with disabilities. Our concern is that the bill has not been made adequately accessible to people with disabilities, and as a result, we have seen inadequate direct input from stakeholders in the disability sector on this important milestone for South Africa. So stakeholders and activists in the disability sector share this concern, and in engaging with our colleagues at the School of Law at Pretoria and at the University of KwaZulu-Natal, we've come together bringing on board equally partners from legal practice to address and surface and engage in this colloquium on academic questions and related disability sector issues that pertain to the bill. Our objective today, what we are really hoping to achieve, is to raise and enhance and deepen awareness within the disability community on the provisions within the bill. What does this bill seek to achieve? Does it go far enough? And what are the critical issues that are identified within the bill? What are the kinds of interventions that are proposed? We make ourselves available to you in your deliberations in identifying the critical issues that impact on you. And we hope and trust that this will enable your meaningful participation in shaping this milestone moment of creating disability rights legislation in South Africa. As we know, this draft bill was published on the 1st of October 2024. The South African Law Reform Commission is leading the process in terms of driving consultation and securing submissions and input. The bill gives effect to the United Nations Convention on the Rights of People with Disabilities. South Africa is signatory to that convention and is therefore obliged to domesticate its obligations, to take its commitments in terms of that United Nations Convention and put that in national legislation so that this can be implemented at the national level. We're obliged in terms of our obligations set out in that convention to establish a comprehensive legal framework to recognize, protect, and promote the rights of persons with disabilities. Through lobbying and pressure, I believe the Law Reform Commission has extended the deadline for public submissions until the 30th of April. And so we have this precious window of just over 6 weeks until the 30th of April 2025 to formulate and make additional submissions for consideration. Our hope, colleague, is through the input provided by the speakers who've been assembled here today. We have a phenomenal lineup of experts in this field. You will note in the invitation that was shared with you their bios, which speaks to their work and their expertise. Through the formal inputs and presentations that they're providing and through our deliberations, we hope that this conversation equips you with the information and the engagement and the deliberation you need to enable you to respond to this call for submissions. We believe this is completely in line with the mantra with which we are all familiar, nothing about us without us. So it is with pleasure now that I hand over to my colleague in the School of Law, a fellow academic and sister on the Navi Pillay Research Group, and one of our colloquium conveners and presenters today, Professor Verleen Holness. Verleen will serve the role as MC for today's deliberations and will introduce you to our speakers. I wish you all a fruitful and impactful colloquium. Verleen, thank you.
Thank you so much, Dr. Hicks. It gives me immense pleasure to welcome our first speaker. After I've introduced her, she will do her presentation and we will carry on down the line with our various presentations until we have the Q&A session at the end. So please feel free to insert questions as the presenters continue within the Q&A box, and as and when they are able to, they will respond to those questions, and those that are not responded to, we will open up at the end so that we can have a wonderful engagement on the inputs that we have from our audience today as well. So thank you, Dr. Hicks. It is my pleasure to welcome Professor Ilse Grobler-Du Plessis, who is the Associate Professor in the Department of Public Law at the University of Pretoria. You will see that she is sharing a venue today with two colleagues who will present later on. Professor Du Plessis teaches, amongst others, constitutional law and disability law at the University of Pretoria, and I will leave it to her to introduce her topic. Welcome, Prof. Grobler-Du Plessis.
Good afternoon. Thank you for the welcome in this regard. I'm here today in academic capacity, where I will then present for you just a quick overview over the convention. Like you will see, I'm putting it up there on the screen. Like I said, it's an academic capacity and not in a role as advisory member to the South African Law Reform Commission. So my task today is just to give you a bird's eye view over the convention, that we are all on the same page when we talk a little bit later and we answer questions, etc. at the end of the session. So I think you're all familiar with the convention, and the convention is building on other international instruments. But this convention that we are now busy domesticating is a little bit different because there is an additional element, like you see on the screen there. An additional element is the element of empowerment. And we see that in the wording of the convention, where it talks about full enjoyment and participation in all aspects of life. And if we look at the convention, we don't see new rights coming from the convention. But we are also familiar with our own Bill of Rights, and we will also see that there are typical human rights that we see in our Bill of Rights also reflected in the convention. But the convention is different because the convention clarifies to state parties like the South African government what their obligations are. Something else about the convention is also that it is a holistic document that basically combines civil and political rights as well as social, economical, and cultural rights in one document. So it's different from other international human rights treaties. And then it's very important, it marks a paradigm shift there at the bottom of the screen of attitudes and approaches toward disabilities. And we see a significant shift from the medical model of disabilities to the social model of disabilities within the human rights model as well. So a significant shift from where people with disabilities are seen as objects of charity, but rather as rights holders, subjects of rights. So if we look at the convention at a glance, I just want to highlight a couple of aspects, and specifically today, the last one on Article 4, we'll talk about a little bit more in detail. The preamble, a very long preamble, but we will see in the preamble this attitudinal change that we talked about with regards to from the medical model of disability moving to the social model of disabilities. And also acknowledging that disability is an evolving concept, and also this attitudinal change about that has to happen in societies, this negative perception regarding disabilities that has to be removed. From the purpose in Article 1, it's very important that we grasp that the purpose says that the convention is there to promote protect and ensure full and equal enjoyment of all human rights and fundamental freedoms. And that is really a mouthful. If we think about full and equal enjoyment of all human rights and fundamental freedoms, it is not about cherry picking in this regard. Important as well, although the convention doesn't define disabilities, it gives us an indication who the targeted group is in Article 1, and we see there, and I'm not going to read it out, who the targeted group is. If we move to definitions in Article 2, we see that 5 key terms are specifically defined: communication, language, discrimination on the basis of disability, reasonable accommodation, and universal design. But that is not the only place in which there is giving scope and content regarding specific terms. We also find that in specific provisions in the convention that also gives us further indication of what the scope and content is of specific terms. Then I just want to move to the general principles. General principles, which we will also look at in the next slide, is there to give state parties like South Africa guidance regarding the interpretation of the convention and also the implementation. And then the general obligations in Article 4, which we are really going to just look a little bit more into detail today, is specifically encouraging national legal and policy reform, and obviously also guiding your governments regarding the implementation of the convention. So on the screen you see there the general principles of the convention. And if we look at those general principles, it is not something new to us. Non-discrimination, full and effective participation, inclusion, respect of inherent dignity. You can go through that list. It's all things that we are familiar with. And it is important for us to understand that these general principles are interrelated to other provisions in the convention. So we will see and encounter them like accessibility in a specific right, and they are to be read with our general principles in the convention. So it assists us with interpretation, and it is also assists the government with the implementation of the convention. If we look at the general obligations specifically contained in Article 4 of the convention, we must also note that the South African government, when it signed the convention in 2007 and ratified it later in November of 2007, it did so without any reservations. And that also means that we cannot cherry pick on what we want to implement into our legal system because there was no reservations recorded. It also means that the state parties to the convention sign and ratify and agrees upon specific terms, and that terms is for the full realization of all human rights and fundamental freedoms of persons with disabilities. Now, implicit in the conventions is 3 distinct duties, and that is a theme that would run throughout the convention. The implicit duties is to respect, to protect, and to fulfill. And what I mean with that is specifically the following. It's almost like a formula, the respect, protect, and fulfill that you see from the obligations in the convention. With regards to respect, state parties must refrain from interfering with the enjoyment of the rights of persons with disabilities. If we talk about protecting people with disabilities, a state must prevent violation of rights by third parties, such as private enterprises, for instance. And to fulfill, we think about a state that must take appropriate action. And what that is legislative, administrative, budgetary, judicial, and other action to realize the rights which is encapsulated in the convention. And if we do that, we empower then people with disabilities. I just want to stand still for a second with regards to the obligations that is imposed on the state, and we are talking here the government who signed and ratified the convention. What are the obligations? And the obligations in the convention is basically on 2 levels. The first level, and I will almost say it's the overarching obligation, is set out in Article 4. So if you want to see what the government's obligations are, We go to Article 4 and we read Article 4. But that is not the only article that we have to look at. Each subsequent article in the convention sets out obligation in relation to specific rights. And that makes it different. That also distinguishes it from our Bill of Rights, because in this convention, in each specific right, it explains to government what the obligations is and what they must do to implement it into ensuring that their obligations are met. And if we talk about obligations, we obviously want to know who has the obligations and what are the obligations. But I just want to for a moment say specific rights, and we know what the rights in our Bill of Rights are. But if we look at the convention, the specific rights are set out there on the screen. It is an enormous amount of rights that you can see. Also, other ones that we don't pick up in our Bill of Rights, like awareness raising, accessibility, and you can go through each of them. And to highlight again, in each of those specific rights, there are specific obligations that has to be fulfilled. And for the next question is, who has then have to fulfill those obligations that is set in those specific rights? And for the next slide, I just want to answer that. Who is responsible? Obviously, the state government will sign and ratify the convention, but that is not where it ends. The state must also ensure that private enterprises must respect the convention and engage in partnership to promote the rights of the disabled. So the role of private enterprise is very important in this regard. And then on the right-hand side of the table, I actually just refer to, just for example, to specific rights where this is mentioned, where it's not only the state's responsibility, but also private enterprises to fulfill those specific rights, to ensure that if there's obligations imposed on them, that they actually have to go the step further to implement it. And this is with regards to the general obligation, accessibility, personal mobility, freedom of expression in healthcare and in work. But then there is also other actors, not only private enterprises. And for that, we will look at the Article 24 on health, specific health professionals. We look at Article 12 on legal capacity and Article 19 on independent living. It will specifically refer to support services and community services. And with regards to Article 24 and education, we specifically see that specific actors like, for instance, qualified teachers has to step up to those obligations. So it's not only the state, the role of private enterprises is important, as well as other actors that is specifically mentioned in this specific rights. What are the obligations? Now we can go, and I can put up on the slides the whole Article 4 and each specific right, but I've kind of just tried to summarize that for you in a table format there on the screen. So what the obligations is, first of all, to review existing law and policies. And I think this is where we talk about the bill today. So that in that regard, it is to respect the convention and the agreement that we have on an international level. We must make sure that our law and our policies is consistent with the convention. And obviously that our legal and policy framework work, the new one that we can adopt or the reform that we make must support the convention's implementation. But just to have specific legislation or pass legislation is not enough. There must be also provision for funding in this regard, because certain aspects of discrimination where we have to prohibit discrimination might have financial implications or require certain funding. Just think about the example of public spaces that is inaccessible. So there must be provision for some that it will have financial implications to make it accessible, and it will require funding. Goods and services make them accessible. If we specifically think about assistive technology, healthcare, education, that is also part of the obligations that we are talking about. Awareness raising, we've seen, that is also an obligation, because many barriers that people with disability faces is with regards to negative attitudes, and awareness raising assists that these negative barriers and attitudes then change. Training on the convention for professionals like teachers, healthcare professionals is very important. And then also data collection is a specific provision in the convention. Data collection is compulsory, and with good data, we can develop better laws and policies and making sure that the convention is implemented. And then obviously there's also an obligation on building capacity for states to meet their obligations for the full implementation of the convention. Now that is at an international level, and all state parties have to go back and think about their own approaches. Some countries have a monist approach. We will not talk about that. That's very academic or dualist approach. But for us at the South African level, we follow a dualist approach, meaning that when we signed this convention and ratified it, it didn't automatically become law in our country, into our legal system. We follow a little bit of a more hybrid approach, but the specific section that we are looking at is section 231 sub 4 of the Constitution, which shares an international agreement. And like we know, the CRPD becomes law in the Republic when it is enacted into law by national legislation. And this is actually where the crossroad where we are at the moment, with the South African Law Reform Commission that is proposing a draft bill, and that is fulfilling that section 231 sub 4 of the Constitution. If we go a little bit further into our Constitution to the Bill of Rights, we know that section 9 protects the right to equality, and disability is also mentioned in there in section 9. But section 9(4) specifically also provides that national legislation must be enacted to prevent or prohibit unfair discrimination. So this bill that flows then, or to be incorporated into our domestic law, will then flow from section 9, a national legislation. And this is where we are at the moment. So if government then passes this bill, it will lead through the section 9 sub 4 provision. I don't want to go into too much detail with regards to our historical history behind getting to where we are from April 1994 up until now. But at this point in time, we are where the South African Law Reform Commission got a request from the Department of Justice and Constitutional Development to investigate the incorporation of the convention. And the Law Commission, which we saw from the discussion paper, basically considered different ways in which we can domesticate the convention, amending specific legislation like the PUDA or the Employment Equity Act, or propose a new piece of legislation. And what we can see from the discussion paper is it proposed a framework act. And if that framework act is then passed, then sector-specific law reform will follow from the framework act. And this is something that I actually just want to stand still on for a second. If we talk about sector-specific law reform, we must look at the obligations, which I just talked about earlier on in the slide. We have a general obligation that is captured in Article 4, but then in each specific right, there is obligations, and that specific sector reform will incorporate or will have to put the ball in the role for the specific sector reform in that area, like for instance, health or work and employment, etc. So that in a nutshell is just to give us a bird's eye view, Professor Holness, I hope I'm within the time, of where we are and what our discussion is going to be based on and what we have to consider when we talk about the bill and what should be in the bill. I'm going to share and stop sharing my presentation just now.
Thank you so much, Professor Ilse du Plessis, Grobler du Plessis. So at this stage, I'm a little concerned that we don't have the closed captioning working. So I'm just going to ask our IT, please, if they could see if they could get the closed captioning to work. We'd really appreciate that. Our next speaker is Mr. Peter Strassheim, and he is a specialist non-practicing attorney consultant amongst many other feats, and he has particular expertise in representing clients with disabilities before various courts over his illustrious career, from issues in relation to labor, health, risk benefits and discrimination law. He is going to speak to us today on a topic that is very close to my heart, and that is looking at the opportunities that this process poses to us. In commemoration of Human Rights Day, which takes place tomorrow, this indeed is a very important milestone for us to be talking about today. So over to you, Mr. Strassheim. Thank you.
Many thanks, much appreciated. And thanks to everybody who's come today to participate in the webinar. I'd just like to firstly flag just how unprecedented this opportunity is. Most of you will know that for about the last century in South African law, in the pre-democratic and democratic era, there's never been any specific laws or recognition of the need for laws for the biggest minority group of persons with disabilities. Now there is, only because of the passing of what Rosa was talking about, the convention. There's never been anything like this before. It's unprecedented, it's a milestone, and it's the greatest single moment that people with disabilities and their supporters have to make sure their rights and their interests and their subjects of concern reach public attention and legislation is enacted to give it, to represent that concern and rectify it. All I want to do is talk about four things today. The first is the importance of the event, but the opportunity needs to be what it needs to be done to pick it up. The second thing is some realities to think about of what does go on in society about people with disabilities. The third is some brief examples of burning issues in society which you might like to consider amongst many others. And then finally, how would you describe your concern and what would you do with the concern once you've described it in getting it to the Law Reform Commission? So then the first one, the discussion paper, if you've read it, it's quite a dense and long document, but it does cover the issues. It covers all the issues that need to be thought about in order to take advantage of the opportunity. And what the Commission did was to not delay things. They produced a draft bill, which is there for everyone to read and to input into. It's a draft in early format. It will need quite a lot of work, I would think, to get it to the level of detail which everybody is going to find reasonable and appropriate. So there's understanding it all is by reading the discussion document and then inputting to take advantage of the opportunity, and inputting to the bill means giving inputs of whatever issues you believe are directly relevant and cannot be ignored. For this, it's worth thinking, I'm going to point to now, it's worth thinking about the realities around disability in society. Now, much of the abuse, I think, that happens and the neglect and the disinterest around disability rights happens not because people want to do it, but because either they don't know what to do, they don't know who disabled people are, or they don't know what they should be doing from a policy, practices, or attitudinal correction perspective. Because of the apartheid past, and rightly and necessarily, the dominant discourses in South African society are about race, gender, and HIV. Why should they not be? Those are key burning issues. Disability has never been. But now, if this opportunity is really taken maximum advantage of, that neglect, disinterest, and disregard would end. This is why the opportunity is so big. Now, I'd like to briefly turn to just a few opportunities to address what I know to be burning issues in society about disability-related matters. You can think in insurance around, in terms of mental illness, are insurers' policies and practices exclude mental illness from cover, exclude suicide from disability benefits if the person didn't complete what they started out to do, and to exclude persons who do succeed from benefits. Then there are, of course, exclusions if you have pre-existing conditions and their waiting periods. And then there's additional costs of cover if you have a disability. You might want to look at those. Sometimes for pre-existing diagnoses, there's no coverage at all. Now, in America, the insurance industry leadership of the biggest insurer has called the insurance industry to review all this. That's what I hope they will do. Another one, which I know is important to many, is access to the built environment. In all the modalities of facilities and amenities in which there is unequal access and therefore exclusion and segregation. But you might also want to look at whether and why architects and designers are not ensuring that the regulations are complied with. And then flowing from that, you might want to look at why it is that local authorities are approving designs and plans which do not include access for people who need that access. In employment, since half of our lives are in employment, only the other half in civil law. In employment, you might like to look at why it is that the latest Employment Equity Commission report has mentioned specifically that for 27 years, the rights of the two designated groups of Black people and of women have rightly and necessarily been complied with, and there's workplace equity and equitable representation for those groups. But for people with disabilities, for 27 years, then it has been. You might like to look at that. And then another one for those who are interested in this field, under the Labour Relations Act, Code of Good Practice dismissal, as you know, covers fair labour practices in dismissal on the grounds of incapacity and disability. And there you might like to consider why the Department of Labour and NEDLAC have for 30 years never amended that code, despite the fact that the provisions of that code no longer represent good practice because they have been superseded by conventions, legislation, common law, and other codes. Finally, in the employment side of things, you might like to look at why COIDA, Compensation for Occupational Injuries and Diseases Act, and why OXA, the Occupational Health and Safety Act, omit mental health hazard removal in the case of health and safety, and do not compensate for work-related mental illness except PTSD. Those are issues I know that are burning issues in the employment sector. If you are an older person with a disability, or you represent older people with disabilities, you might like to look at whether there should be criminal offences for continued abuse of vulnerable people. You all know recently the Department of Justice decided that they would now publish the register of sexual offenders in relation to women and children, make it accessible to the public. And of course, that is offences in relation to women and children. But as you will recognize, people with disabilities, particularly neurocognitive and intellectual disabilities, are as vulnerable as any woman and any child, but they seem to have been ignored. So you might like to look at criminal offences for abuse And because we all know that, unfortunately, people with dementia and Parkinson's and other cognitive declines are subjected to all sorts of malfeasances in relation to early access to finance, to money and benefits from beneficiaries. You might like to look at advanced directives. If you represent older people, you might like to look at whether people who do live with cognitive and neurological impairments should ever be charged with criminal offences when there's no intention to do them because of the neurocognitive decline. Now, of course, those are all burning issues in civil society and employment. But of course, the umbrella that covers both of them are attitudes and perceptions. Everybody knows that the social model says, and objective law proves, that the greatest barrier to equal opportunity and non-discrimination for people with disabilities is the attitudes of others rather than the impairment or disability they live with. So one wants to think about methodologies and measures to start addressing the attitudinal deficits which leads to the discrimination that we see. So as Ilse has mentioned, there need to be interventions, trainings, awareness raisings, and all sorts of other things to deal with inappropriate attitudes. And if you look just briefly at how these attitudes evolve and why some of these attitudes are actually harmful to the person who has these attitudes about people with disabilities, you get to understand that in many cases, these attitudes arise not from maliciousness and vindictiveness towards people with disabilities, but by the fact that there is inadequate information and there is ignorance in the sense of a lack of knowledge, and then uncertainty about who disabled people are and what their rights are and where to find those rights. One wants to think whether you might want to recommend, in particularly the bill, whether there might be fines for people who clearly should know about what discrimination is towards people with disabilities and who must know about where they will get the information to adjust their attitudes and recalibrate their thinking that haven't done so. Should there be fines? And finally, because I'm going to stop talking, I want to talk about the unfortunate reality that civil society seems to take advantage of disability rather than respect it and prevent it. So the issue that then arises is, what might you consider including as judicial mechanisms to try and address discrimination, malfeasance, abuse, grave forms of harm, financial misconduct towards people with disabilities that need to be addressed now? They can't wait. Because if you've been reading your internet on the state of justice in the country, you will know that to get your Labour Court case heard by the Labour Court takes about 3 to 4 years from the date that you first lodge your dispute. It's somewhat worse if you want to think about the High Court. According to the reports I've read, getting your dispute into the High Court will take 6 years if you report it now. Now, this is a massive concern to the Department of Justice, and we respect them for having that concern. It's a massive concern to the departments of the heads of the courts. But the one place where you can, if you like, get your dispute heard quickly is if you go to the pension funds adjudicator, if you go to the Ombudsman for Insurance and Financial Advice, and importantly, if you go to the CCMA and the Bargaining Councils for Labour Disputes. So if those three work, and you can get your dispute heard within 30 days, what might you like to consider about how the abuse of vulnerable disabled people who need their right or their interest addressed or the duty to them enforced as fast as possible? What might you like to consider about that to get those things done quickly? Of course, you could consider a tribunal very similar to the CCMA. You could consider a body very similar to the Ombudsman, but they would have to take decisions very quickly, and they'd have to be guided by social workers, lawyers who know something about disability, organizations of and for people with disabilities who know about disability, and of course, primarily and most importantly, people with disabilities themselves. So those are just thoughts I have of things you might like to consider if you believe those things to be burning issues in employment and civil society. So to my fourth point then, what would you do about the points that you do want to raise? I would recommend that you and the organizations that you're working with and for, you might want to consider describing them in a very short way, which will describe exactly what that point is. And then once you've done that, you of course give a short description of why it is an issue to you. That's the second thing. Then the third one is, what do you recommend for how to solve that issue? So three things. What is your issue? Described in a line or so. Then why is it an issue? Why does it cause harm? Why does it discriminate? Why does it cause loss? Why does it cause breach? And all of those things. And then finally, thirdly, what is your idea, demand, recommendation to resolve it? Finally, fourth piece of how to get your solution heard and carefully considered by the people who do so is, do you think it should go into the bill that you have in front of you? Because it's so important. It covers all fields in civil society and it covers all disabilities. Or do you rather think instead that because it doesn't cover all fields and it doesn't cover all disabilities, it should go specifically into a piece of legislation that will cover that particular issue, like, for example, the Insurance Act, the Health Act, legislation on transport, legislation on the built environment and architecture, or employment, all of those. So that's really what I'd like to say. Those are a brief summary of the four things I had. Perhaps the most important is, what would you do? And that's the last one. Describe it as well as you can, briefly. Explain why it's an issue. Thirdly, explain what your solution is. And then finally, suggest that it should go in the bill because it's so important it can't be ignored. Or rather, instead, that it should go into subsidiary legislation that will come afterwards. So thank you very much. I appreciate your listening to me and to give me this opportunity. It's much appreciated.
Thank you so much, Mr. Strassheim. Next, our speaker is Advocate Carla van Veenendaal, and she is an advocate that has been practicing since 2010. And prior to that, she has good experience with a legal aid provider. Today, her topic with us will be on mediation and litigation, and her topic is making rights real. Thank you so much, Advocate van Veenendaal. Welcome.
Thank you very much, Nadine. Thank you for the opportunity to have a little bit of a chat today to everybody. I'm going to go a little bit forward in where do we want to head eventually with the rights that we have and making them real in terms of the practice of law. I'm unfortunately a practical person because I practice law. I'm not a very theoretical professor, so my attitude will be how does it go into practice? When one reads the discussion paper on the domestication of the UKZN,
then you've got to also look at specifically one of the public recommendations is page 69, which reads at 5.41, effective legal protection cannot be confined to costly litigation, civil litigation. Effective must mean appropriate dispute systems design that includes litigation, arbitration, mediation, and criminal prosecution.
Advocate van Veenendaal, we seem to have some interference. Could we just double check that there's no other recording in the room? If you could just speak so I can just double check that I can hear you clearly. All right. Please continue then. Apologies for that interruption. We just want to make sure we're audible, particularly since the closed captioning is not working. Thank you.
Trained professionals are responsible for enabling people with disabilities to advocate for and enforce their
Apologies,
rights.
Advocate van Veenendaal. The sound is simply not working well. What I think we're going to do, because we really do want to ensure that we can hear you clearly. I see that there's an echo as well.
Sorry?
Let's see again. Please try one more time.
Regarding paragraph 5.41,
Excellent, thank you.
Institutions staffed by competent and trained professionals must be responsible for enabling persons with disabilities to advocate for and enforce their rights. Now, this paragraph is the starting point of ensuring that in the practice of law, legal practitioners assist persons with disabilities in terms of the envisaged domesticated UNCRPD in enforcing rights and ensuring that they be seen, heard, and given consequence. What would that entail? Let's look at the options. Do we have civil litigation? Can we look at criminal charges? Can we look at mediation and arbitration? Mr. Strasheim has referred to that. Can we look at alternative problem-solving structures? Now, effective legal protection cannot be confined to costly civil litigation. But we need to have appropriate dispute systems to be designed at the same time as we have this domestication taking place and the reconsideration of all legislation in the second phase with the view to being brought in line with the soon-to-be domesticated UNCRPD. Institutions need to be equipped after identification with the appointment of trained professionals who can take up the responsibility to enable persons with disabilities to advocate for and enforce their rights. Now, what kind of institutions can be identified? We have the possibility of an ombud, but we must also look at overlapping issues between the different ombuds offices that may make this ombuds office merely an office to bounce problematic situations from one office to the next without affording the disabled person resolution once his rights have been infringed or to avoid discrimination from continuing. The same thing may happen if a Chapter 9 institution must be approached. For example, the public protector will not lose the ability to investigate. The Human Rights Commission still may be able to investigate certain infringements as well. But both of these offices may say very quickly that they don't have the budget for this, and they may say, well, we don't want to touch this, hands off. They don't touch persons with disabilities. And the consequence is that persons with disabilities become invisible again. Current tribunals and current commissions that have been identified may similarly overlap. So where would a person with a disability or the caregiver of such a person go for redress? Where would one start? What would one be able to expect? Can one ask for monetary relief? Can the persons be prosecuted by the state in criminal court? Can a state department be prosecuted in a criminal court, for instance, because the bill is creating offences? Let's look at civil litigation. It is costly. It is beset by problems of court dates that are far in the future, by which time any effective remedy for the protection and enforcement of any right or any redress due to discrimination would become null and void and consequently meaningless. There must be a faster solution which can immediately redress discrimination and any ill consequence. A tribunal may possibly establish with the necessary budget and with powers of immediate and urgent interference, with the power to mediate, to arbitrate, and to bring resolution for a form of discrimination or an infringement of rights so that they be brought to a quick end. Professionals that are referred to can then, in this instance, not only refer to lawyers, but also to specialist occupational therapists, to specialist physiotherapists, specific psychologists and psychiatrists. If you look at the older persons, then you can look at the gerontologists, persons with managerial expertise specifically in the sphere of persons with disabilities, and more. In criminal law, we can create strict liability. That is, to statutorily describe offences which leads to liability in terms of a crime simply because the statute has not been complied with. An analogous example is that of the possession of a firearm, which simply says that a person who is found in possession of a firearm without the necessary permit to possess such is then immediately prosecutable regardless of his good or bad intention to hold that firearm. Animus does not matter. The act of possession, the act in this instance of infringing on rights, is the only thing that matters. And that will then cover companies, persons, and governmental institutions. Now, the current version of the bill creates offences which render persons who commit acts of discrimination on the basis of disability liable in terms of the criminal law and grants guaranteed equal and effective legal protection. Punishment has not been fixed yet, nor has the issue of arrest and bail been addressed. And currently, there's a comment that closes at the end of this month in terms of arrest and bail. Now, would a suspected infringer then be arrested, held without bail, granted so-called police bail, or should he be held in terms of Section 60 for at least the first appearance and then further investigation and or bail application, or in terms of Schedules 5 and 6 if he's a so-called repeat offender? Or should he just be brought to court by a warrant? We need to think of these. Will there be a provision to fast-track these cases so that redress can be made immediate in terms of the principles of restorative justice? In other words, can it be envisaged that an accused or accused organisation company be ordered upon a very summary trial and evidence that the infringement be redressed through either a monetary award or through, for example, making changes to a building or building a ramp or appointing a facilitator or an interpreter using closed captions? I would suggest it is high time that the South African law moves towards embracing the principles of restorative justice, which Judges Busielo and Bertelsmann have campaigned and fought for since at least the beginning of this century. All and not only unfair discrimination must be prohibited if one looks at this bill. Not once is the word unfair used in the CRPD. In this sense, the bill then goes further than our PUDA, and liability can vest when a person unintentionally or negligently commits an act of discrimination. But criminal law has one drawback. It does not provide for a fine to be paid over to the person discriminated against or for remedial action to be taken to assist the person with this disability to be granted some relief. Fines go into the coffers of the estate. It is recommended that the restorative justice attitude here will go a long way to assisting a victim of discrimination. If the fine were not to go into the state coffers, but go to either the victim or to an organization who can represent the victim so that meaningful redress can take place. Diversion in the form of time served at an organization that represents that rights of the person with a disability can also be considered. Furthermore, it has to be also then decided whether these crimes would be prosecuted in the district court, magistrates court, or the high court. I would suggest the high court, as it has the same vulnerability factor as domestic violence, femicide, and gender abuse. This is once again victims that are there for the taking. Returning back in civil action, it is an alternative route, but it's so expensive and so time consuming while wasting time, or more elegantly put, it is not effective within an urgent timeline. Can it offer any alternative or additional remedy? The Equality Court is available and should be considered. Timelines should then be strictly enforced with a view to urgency. Possible redress orders are very wide in terms of the scope granted by the Equality Court by the PIPUDA, but this bill goes wider than PIPUDA, and the powers of the Equality Court should be recognized in terms of the Framework Act. What would be the role of legal practitioners? All of what I've said before is based on the possible scenarios that may emanate from the framework legislation and the further development of the law and legislation. What does need to happen is that student lawyers, candidate attorneys, and pupil advocates must be exposed to persons with disabilities in all their forms, physical, mental, and intellectual disabilities. They need to learn about the impact of disabilities on families and communities. In rural areas, persons with disabilities are hidden, they are made invisible. Some are made out to be witches or ghosts or worse. Perceptions need to be changed. The needs of elderly persons whose abilities change over time need to be explained and taught on a far wider scale than currently. Practitioners would have to realize that this is a sector that needs experience. Clients need to ensure that when they approach a practitioner, that they ask the practitioner about his or her experience in this sector. Attorneys would then have to be honest with their clients if they are not experienced to take on clients with disabilities. This is a specialization field. I foresee that this field should be recognized, and to a certain point, I would advise that only older and more experienced lawyers take on these matters to ensure that urgent and incisive change to the circumstances of persons with disabilities will be enforced and implemented. I thank you very much.
Thank you very much, Advocate van Veenendaal. That is a really beautiful segue to the kind of initiatives then that we would also want for children with disabilities. Next, it gives me great pleasure to welcome my fellow colleague, Professor Bridget Clark, who is from the University of KwaZulu-Natal. She's a family and children's rights academic, and she will be speaking to us today about how the domestication process will improve the lives of children with disabilities in South Africa. Welcome, Prof. Clark.
Thank you very much, Prof. Holness. Really, what I've heard and what I know, conventions, legislation, and policies are of little meaning and use unless they are implemented and enforced. Progress in the implementation of rights for children can only be made in South Africa if there is sufficient will and there was sufficient implementation and monitoring. So in this presentation today, I am going to, if I can go to the next slide. My presentation is in 4 parts. I'm going to look at the CRPD and its examine it in relation to children, and its relationship to the Convention on the Rights of the Child, the CRC. Then I'm going to look at some of the barriers for children with disabilities in South Africa, the gaps perhaps in the draft bill, and on the protection and promotion of persons with disabilities, but I'm specifically using the word children, and I'm going to make some recommendations. If I could go on to the next slide. Thank you. Next slide, please. Sorry. So the CRPD revolutionizes the way law approaches the law's response to the rights of persons with disabilities. And in this respect, with focusing on children, it interacts with and builds upon the Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child. The CRPD's monitoring committee offers a constructive, rights-based framework for protecting children with disabilities. And the key concepts for children, as for adults with disabilities, are non-discrimination, inclusion, accessibility, reasonable accommodation, and additionally, the best interests of the child. So the preamble in R recognizes the CRC's importance for children with disabilities, that they have, as has already been stated by our previous brilliant speakers, the full enjoyment of all rights on an equal basis with other children. And Article 4, the general article, which was outlined by Professor Ilse Schrobbelaar, the principle of participation is actually reflected there, which it also aligns it with the CRC, requiring children with disabilities to be consulted. And Articles 4.3 and 7.3 emphasize respect for the evolving capacities of children with disabilities and respect for the rights of children with disabilities to preserve their identities. Article 7 is, in fact, a specific children's provision. And in fact, the word children comes up 28 times in the convention and not so many times in the draft bill. I think it was 14 times. Article 20, there's a specific children's provision in the convention, which is not present in the draft bill. Article 23 of the CRPD also emphasizes the child's right to respect for family life and requires that a child shall not be separated from his or her parents. So again, this emphasis on what was brought forward in the consultation process, by the Centre for Child Law, opposing the institutionalization of children with disabilities. So they should not be separated from their parents against their will, except when such separation by a court is deemed necessary for the best interests of the child. So the general provisions of the CRPD would apply equally to children as they do to adults. For example, Article 11 requires states parties in situations of risk or emergency, that could be anything related to climate change or disaster, to protect children with disabilities. That's not specifically mentioned at all in relation to even persons with disabilities in the draft bill. And when one thinks of the impact of climate change on persons with disabilities, and particularly on children with disabilities, perhaps in wheelchairs, whatever, children with disabilities would particularly need to be included in an emergency disaster plan that was a national emergency disaster plan. And then Article 8, particularly important, obliges state parties to establish awareness-raising programs to combat prejudice. And we know that prejudice and attitudinal attitudes are perhaps even worse than resource challenges in dealing with persons with disabilities, and particularly children. Children often denied even access to education, kept at home, regarded as a curse, or the stigma attached to them. All that needs to be, there needs to be training against any negative attitudes towards children with disabilities. And in particular, the barriers in relation to education, limited access to inclusive education, lack of assistive resources, These are barriers encountered every day by our children with disabilities. Transport problems, not able to get their wheelchairs into even a taxi, all these lack of reasonable accommodation at the schools, and then special schools, which we heard from the evidence produced given to the South African Law Reform Commission were inadequate. The gaps in specialized healthcare, rehabilitation services, and particularly something very close to my heart, the lack of provision for early childhood intervention, screening, and assistive device provision. We know that the first 1,000 days of a child's life that is where the most of the brain development takes place. And if they can be screened, if children with disabilities, with neurodiverse can be screened at an early stage and given assistance and support, the outcome for such children, prognosis can be, their barriers can be, it's so much easier for them to cope with any problems that they may have. And then again, institutionalization of children with disabilities. There was a very strong representation against this, and that should really be reflected in the draft bill. As I said, lack of emergency plans for climate change and disaster, lack of data on children with disabilities, inequality between urban and rural areas. We know that children in remote, rural, poverty-stricken areas with disabilities are really have had the most encounter the most barriers to the exercise of their rights. And that is really what their disability, it's not so much a disability as a barrier that is put in place by society, which prevents them exercising their rights to education, healthcare, etc. So in terms of disability grants, children with disabilities are they're only allowed a grant if they are needing permanent healthcare and support, and that needs to be, obviously, finance needs to be much more broadly drafted. Participation of children with disabilities and their organizations in the development of legislation to implement the convention. That is specifically stated in Article 4. And the need for states parties to closely consult with and involve children with disabilities. And I wasn't sure, there was the Centre for Child Law made representation to the South African Law Reform Commission, but there wasn't any specific reference to children with around 17, 18 children who had the competency and the age to feed into this consultation. So one would like to see more child-specific provisions in terms of Article 16.5, particularly against violence against children with disabilities. One would like to see perhaps more accountability structures. There's a slight vagueness around implementation. I know this is a monitoring act, but there's no independent monitoring body for children's disabilities rights. Perhaps a national children's commissioner could be provided for, but with particular, who would be able to particularly focus on collecting data and ensuring that children's disability rights are attended to. And the provisions for inclusive and accessible education are really followed through in terms of Article 24.2a. There's limited resource to assistive technology and resources, and there is a failure to address discrimination in schools. These are all barriers that exist in South Africa at the moment. Social protection, inadequate support structures for families and caregivers, which are required by the CRPD in terms of Articles 23, Article 28, the need for respite care for carers, public awareness, critical. We need awareness raising campaigns to work against the stigma and discrimination, which hinders child's social participation, the cultural and customary beliefs that hinder their full participation in society. So there are also insufficient mechanisms for family support, awareness raising, limited financial assistance, lack of support for mental health. There'll be more discussion about that, I'm sure, later, particularly for children, inadequate provisions for early intervention, and a lack of specialized healthcare in terms of Article 25. No clear funding commitment for disability-related healthcare services for children with disabilities. So my recommendations would be to the Commission, the South African Commission, to strengthen the child-specific provisions in terms of Article 16.5 and Article 7. Guarantee inclusive, I know the Article 24, which deals with education, in fact, just talks about persons. It's one of the provisions which is not specifically, children are not specifically mentioned so much, but children are obviously in primary and secondary education, the ones primarily affected by that. So I would argue that guarantee inclusive education with resources and teacher training needs to be particularly focused on and also focus on early childhood education. Direct support for families with children with disabilities, particularly in rural communities. Established enforcement and monitoring mechanisms. Conventions, legislation, and policy are of little use and meaning unless they are implemented and enforced. Improve access to healthcare and early interventions, awareness raising, and disaster management. Access to play and recreation facilities in terms of Article 30D, healthcare and early childhood development. Conduct regular monitoring and evaluation of policies, promote accessibility, enhance effective technology and learning materials for children with disabilities. My final word is that there's need for a child-centered approach in disability rights legislation. South Africa could adopt a national disability strategy, such as was suggested by the United Nations Assembly in 2024. Education reforms for CRPD compliance, removing the barriers to children's full enjoyment of all their rights and freedoms in terms of the CRPD, strengthening inclusive education policies. And finally, effective practical measures must accompany any legislative reforms. And there must be a collaboration between government, NGOs and communities in ensuring that children are not left behind. Thank you.
Thank you very much, Professor Clark. That discussion on children, of course, could take us many, many days because children really have a whole host of rights attributed to them under the international law. And quite peculiar to me was that the bill put in one provision the rights of the elderly, women and children. So we're just smacking them together collectively, and we're hoping that, you know, we can pick up on some strains there that relate to children. So for me, that's quite a peculiar approach that the drafters took of this bill. Thank you so much, Professor Clark, for your input. Our next speaker is Dr. Lindani Ngumalo. He is an honorary research fellow with the School of Law at UKZN, and he is a senior manager in employment law at the eThekwini municipality. His specialization is employment law in particular, and he has written on transformational leadership, particularly in relation to disability inclusion. His topic today speaks to the implications of this bill in the workplace and in labor law. Thank you so much for joining us, Dr. Ngumalo.
Thank you so much, Prof. Holness. Let me just quickly share my slide. So, as already mentioned, Dr. Ngumalo, I will be looking at the implications of the draft bill on the protection and promotion of PWDs in the workplace. As I was actually preparing for this colloquium, I was reminded of the work by the late Prof. Ngwena. There's something disturbing me here, Prof.
We can hear you very clearly from my side.
Okay, thank you very much.
Your voice is very audible. Thank you, Dr. Ngumalo.
Thank you. Yes, I was reminded of the work by Prof. Ngwena, and I've quoted it as part of the introduction. And it says that the treatment of people with disability in the workplace raises difficult question on how to secure full enjoyment of human dignity, equality, and freedom for a minority that has been the object of entrenched marginalization. It brings to the fore questions about efficacy of law as an instrument for securing equality and social justice for people that have historically been assigned to the bottom of social ladder. In the workplace, it raises
Dr.
questions.
Nxumalo, apologies. Can we ask you to put the slides in presentation mode for our participants?
Oh, sorry.
Thank you so much.
Is it now visible, Prof?
Not quite. So it might take a while to click in, but if it's not working, go to the bottom of your screen and click on what looks like, yes, that one. Perfect. Thank you so much.
Thank you very much. So I was actually referring to the work by the late Prof. Ngwena. And as I was preparing for this seminar, this actually talks to exactly what the bill intends to do. It seeks to address the aforesaid by inter alia giving effect to the rights and obligations under the Constitution and ensuring effective participation and inclusion of persons with disability in society, including the workplace. It further calls for equality of opportunity, full and equal enjoyment of all rights and freedoms, reasonable accommodation and affirmative action measures for persons with disabilities in the workplace. The bill is therefore a step in the right direction towards underscoring the need to address challenges faced by PWDs in the workplace, which include inter alia physical, environmental barriers, attitudinal social barriers, communication, policy, and systematic barriers. From an employment standpoint, it will have an impact on interpretation of existing labor laws, especially those relating to recruitment and selection, employment equity, and fair labor practice. I will then look into the key provisions as they relate to workplace and start with reasonable accommodation. So the Section 8 of the draft bill deals with reasonable accommodation and regard accommodation as a right of PWDs towards them functioning independently and participating fully in all aspects of life. I think this is important because we are now, for the first time, getting this as confirmed as a right of persons with disability. It requires the state and any person who provides reasonable accommodation to confer with PWDs or their representatives. But the bill is silent as to what does the word confer mean. Does it mean working together and finding solution towards reasonable accommodation? And what happens if there is no agreement between the parties? The bill provides for undue hardship as the employer's defense towards reasonable accommodation after careful search and assessment. What does the assessment entail? It is perhaps not clear, and that's why I said maybe the bill should be clearer and provide some guidance in this regard before a defense may be used by the employer. Now, the bill also talks of necessary accommodation. Section 9 provides that PWDs must be given the bare minimum needs to optimize their physical and intellectual participation in the public life. Section 9.2 states that necessary accommodation must be made available on request. Now the question is, what is regarded as public life? Does it include workplace? Is it not possible for an individual with disability who is seeking employment to rely on Section 9.2 for necessary accommodation? So while there are the definition in this regard, in its current form, the provision could create challenges and may be subject to various interpretation. And perhaps there should be a definition of public life so that it becomes clearer which one will be more applicable to a place, if not both. With regard to barriers and accessibility, the state is required to implement measures to identify and eliminate barriers to accessibility. From an employment standpoint, the state may, in consultation with the employer, assign a duty to remove barriers for PWDs. The practicality of this provision remains to be seen, as the bill does not clearly provide for enforcement mechanism. While the bill establishes the Conflict Administration Unit, it appears that its role will be to administer the resolution of conflicts arising from interpretation and application of the Act, and not necessarily the enforcement of legislative provisions. That function will remain with the Department of Employment and Labor through the labor inspectors, who I submit have failed to enforce disability provisions in the workplace, including taking legal action against those that are not complying. Sorry, I was actually disturbed by the comments. So who have failed to enforce disability provision, including taking legal action against employers who, without justification, have failed to remove barriers for persons with disabilities. Now, when it comes to
while you catch your breath, I'm going to just make one announcement. Could we please ask our participants question and answers in the Q&A box so that it doesn't pop up as a chat to disturb our presenters? So that would be really appreciated. Your queries and your questions in the Q&A box. And then also, just to advise all participants, the recording is currently being live streamed on the YouTube channel, so you can access it there, and a recording will also be made available afterwards to everybody who registered for the webinar. So please don't worry about the slides or the presentations that shall be shared. And then lastly, Dr. Nxumalo, if you could just share again your screen from where you left off before you were disturbed. Apologies for that.
Okay. Okay,
and Nxumalo, just to remind you again to share it quite large so we can see it clearly on the screen.
Thank you.
Thank you.
So with regards to right to work, Section 19 deals with the right to work. It provides, among others, that the state must safeguard and promote the realization of the right to work by implementing measures to promote employment opportunities and career advancement for persons with disabilities in the labor market, and assistance in finding, obtaining, maintaining, and returning to employment. I think this is certainly encouraging and may call for review of the Code of Good Practice on employment of persons with disabilities, particularly the section dealing with recruitment and selection. The state will have to develop practical measures to ensure that persons with disabilities are employed, retained, and advanced in the workplace, and that they are provided with opportunities to acquire work experience, which appears to be a challenge at the moment. Perhaps the bill should also underscore that employment opportunities must be sustainable for PWDs. Protection against discrimination. PWDs have the effective right on an equal basis with others to the provision of reasonable accommodation in the workplace, in public spaces, rendering essential services, and in their living spaces. Also, they do have the right to just and favorable conditions of work, including equal opportunities and equal remuneration for work of equal value, safe and healthy working environment condition, including protection from harassment and the redress of grievances. The bill further underscores the right to the implementation of legislative and all other appropriate measures to modify and or abolish existing laws, regulations, customs, and practices that constitute discrimination against persons with disabilities. It is prohibited to stereotype, prejudice, or harm persons based on disability regarding matters concerning all forms of employment, including conditions of recruitment, hiring, and employment, continuance of employment, career advancement, and safe and healthy working conditions. Now, the bill establishes or mandates the Minister of Department of Women, Youth, and Persons with Disabilities, alternatively Department of Justice, to establish conflict administration unit to administer resolution of conflict arising from the interpretation and application of the Act. Looking at the wording of the bill in its current form, it actually leaves the establishment of the unit to the aforesaid department instead of the Act itself establishing the unit. For example, it should state that the unit is hereby established within the aforesaid department and not to actually leave it to the department to establish the units. Or rather, yes, the unit. Additionally, it should set out the functions and powers of the unit, as Section 34 only set out the procedures for dispute. From an employment law standpoint, it is not clear whether the unit and CCMA will have a concurrent jurisdiction to deal with dispute arising from the Act. But having said that, it appears that it is not mandatory to refer a dispute to the unit, judging from the wording of Section 34(1) of the bill. And then, of course, the bill establishes the Equal Opportunities Office. Unlike the establishment of the unit, the bill establishes the Equal Opportunities Office, or the office in the Department of Women, Youth, and Persons with Disabilities. Like the unit, it is not clear what the powers and functions of the office are, save to say that it acts as the intermediary between complainants and the appropriate authorities. The Commission for Employment Equity was established in terms of the Employment Equity Act. Therefore, the bill should clearly set out the powers and functions of the office to avoid a possible duplication of functions. The bill should also deal with the undertaking to comply, especially for those authorities who would have failed to attend to the complaints raised by the office. So I've actually listed some of the comments to say the bill, if enacted, will impact the workplace and labor law function by strengthening protection against discrimination, mandating reasonable accommodation, and promoting inclusivity, potentially leading to changes in recruitment and selection practices, workplace policies, and dispute resolution mechanism. It has the potential to solidify the legal basis for non-discrimination in the workplace, and from an enforcement mechanism point of view, the establishment of the Conflict Administration Unit and Equal Opportunities Office may strengthen mechanism for enforcing disability rights. While the bill regards accommodation as a right of PWDs towards them functioning independently and participating fully in all aspects of life, the bill is silent about assistive technology, which could play a key role in accommodating PWDs. It does, however, state among its purposes that PWDs should have access to technology. With regard to dispute resolution, the bill may have an impact on the resolution of disability dispute, and there may be a need to amend existing employment legislation. Lastly, I think the issue of trade union is one of the aspects that need to be looked at, as I believe that they can play a key role in ensuring that PWDs exercise their rights on an equal basis with others. The bill could possibly expand on this and underscore a need for collective bargaining to be inclusive of issues affecting persons with disabilities. The Constitution promotes sound labor relations and allows employees to join and partake in trade union lawful activities, while Section 23(5) allows trade union to engage in collective bargaining. Thus, trade unions are constitutionally recognized and have a key role to play towards ensuring inclusion and sound talent management approach that is inclusive of persons with disabilities. Thank you very much.
Siyabonga kakhulu, Dr. Nxumalo. It is lovely to have you today. And I'm really grateful for your tribute to the late Dr. Professor Charles Ngwena, who was a giant amongst us, not only in relation to employment law, but also in relation to disability law. Thank you for that. I then have the absolute pleasure of now taking you through the last presentation before we will have a very short question and answer session. Please, ladies and gentlemen, once you leave here, don't let the conversation end. You are welcome to contact us so that we can continue our engagements. And just a reminder of the deadline for submissions for the Law Reform Commission on the bill. By necessity, our short time together today cannot cover all of the aspects of the bill, and we've just cherry-picked a couple of issues that are important for us. Remembering that this bill is a framework law. What that means is that it identifies structures for government accountability and for other processes that would guide the decisions and the actions that are to be taken by government, the executive, and of course, other actors that have been identified in that particular bill. It clarifies who the stakeholders are that are to be held accountable for taking action, and it specifically underscores the need for coordinating cross-sectorally. So as we've seen, we've already touched on a couple of sectors: health, education, employment, the justice system. And it's really important that each one of those sectors on their own and then collaboratively also ensure that they take on board what this process of domestication means for our country, what the bill would require of those particular functionaries, and how that would play out, not just in terms of implementing this bill, but all of the various legislation, regulations, and policy changes that are going to be necessary once this bill is enacted. So this is a countrywide conversation that should be happening in every boardroom, in every office, in every corridor, and obviously should be at the center of consultation, not just with persons with disabilities, but driven by persons with disabilities to identify their needs. And that is why Mr. Strassheim's advice is just so important for the disability community and the sector to identify what the challenges may be in the bill or in society generally, identify what the harms are occasioned, and then, of course, what we need to do to address those and send those submissions to the Law Reform Commission. My talk today focuses on access to justice, and we've got a few links already made by previous speakers, for example, Advocate van Veenendaal and Mr. Strassheim, identifying just some of the challenges that we already face within the justice sector when it comes to effective access to justice for persons with disabilities. But what are we talking about exactly? So Stephanie Ortleva defines access to justice as encompassing people's effective access to the system, procedures, information, and locations used in the administration of justice. We know that there are multiple barriers to accessing justice for persons with disabilities documented globally and in South Africa, such as geographic and transport barriers, linguistic and financial barriers, attitudes that are pervasive like paternalistic beliefs around questioning the abilities of persons with disabilities to participate in all the phases of the administration of justice, and of course, accessibility barriers. Our court procedures and documents are often not procedurally accommodating, in addition to physical and communication barriers experienced when navigating the justice system, and documents and pleadings are often not made available in accessible formats. In fact, this bill is only made available in a Word format. There's no easy-to-read format for us to engage with for persons with intellectual or other disabilities. There's no sign language version with closed captions, and there also isn't an audio version for persons who prefer to listen to what the bill has to say. Then, of course, barriers generally in the justice system is the lack of training, as already alluded by Advocate van Veenendaal, for professionals working in the field of justice. And this doesn't only include lawyers, magistrates, and judges. It also refers to social workers in their statutory duties, health workers when they are engaging, intermediaries, interpreters, the entire value chain of the justice system, including prison staff, law enforcement staff like the police, the Metro Police. All of them are implicated by the barriers currently in the system and do not have the requisite training. But of course, it's not all bad, because there are facilitators that can help us to overcome or mitigate some of these barriers. And these have been identified in the CRPD. They talk to the prohibition of discrimination on the basis of disability, having accessible court systems and places, including universal design, reasonable accommodations offered where they may be necessary, and then crucially, the recognition of legal capacity with support offered when it is needed, with safeguards in those instances, and then procedural accommodations that are age and gender appropriate where they may be needed, access to information, including legal documents and personal health records, they might, or other records that might come before a court. And then appropriate training is required by the CRPD of court officials and all stakeholders in the justice value chain. So these facilitators are identified in the CRPD, and of course, South Africa has ratified and now in effect is the African Disability Protocol. That is the protocol to the African Charter on Human and People's Rights on the rights of persons with disabilities. And that protocol is an African answer to some of the challenges that have not been addressed in the CRPD that are faced by persons with disabilities. And some encapsulations are even stronger than the CRPD. So I really do urge you to go and look at what the protocol has to say, because those are also now binding on South Africa, and we should be domesticating the protocol as well. An important facilitator for access to justice is the provision of legal representation. We know how often our litigants are unrepresented, or when they are represented, whether the quality of the legal representation is appropriate. I have many clients referred to me who seek representation, and the capacity of lawyers to assist them isn't always what it should be. So the disability protocol requires states parties to ensure legal assistance, including legal aid to persons with disabilities, a much stronger requirement and obligation than is found in the CRPD. We also have guidance on what the CRPD requires in relation to Article 13. That is the provision that speaks to access to justice. And this is in the international principles and guidelines on access to justice for persons with disabilities. And that is primarily because there's not yet a general comment that gives us interpretive guidelines on what these particular provisions mean. So this is a stand-in the meantime, and an excellent one, drafted by a whole range of experts with key input by persons with disabilities. Principle 8 from these guidelines says that persons with disabilities have the right to report complaints and initiate legal proceedings concerning human rights violations and crimes, and to have their complaints investigated and be afforded effective remedies. The guidelines articulate that this obligation means that states must have accessible, easy to use, transparent, and effective mechanisms for individuals to report complaints about human rights violations and crimes, and that complaint adjudicators and tribunals must provide remedies that are individually tailored and may include redress and reparation. So this guidance is clear that there are a couple of elements that our mechanism should ascribe to. I repeat them: accessibility, ease of use, transparency, and effectiveness. 4 key factors. So the South African Law Reforms Commission's approach to domesticating the CRPD in this bill is premised on incorporating a large amount of provisions from the CRPD, which mirrors it in part, okay? But when we're looking at access to justice mechanisms, we're going to focus on a few key ones. And I'm going to share with you my presentation, the 3 ones that are identified in the bill. All right. So the 3 mechanisms are for adjudication of disputes in relation to complaints of unfair discrimination, a conflict administration unit, and or the Equality Court is identified as the forum to approach by clauses 33 and 34 of the bill, and these are to be established by either the Minister in the Department of Women, Youth and Persons with Disabilities or the Department of Justice. This was already alluded to by my colleague, Dr. Numalo. Then the second mechanism is for review of support and safeguards offered in the exercise of legal capacity, the South African Human Rights Commission and or the Equality Court are identified as the relevant review forums under Clause 7(e) of the bill. And then third, a referral mechanism of complaints from persons with disabilities and their representatives is identified, the so-called Equal Opportunities Office, which should be established by the Department of Women, Youth and Persons with Disabilities, and would be a referral mechanism to appropriate authorities under Clause 35(1) and 2 of the bill. Then, as alluded to earlier, Mr. Strassheim identified that there are some alternatives that we have available that are not mentioned in the bill, that there already is in place some good practices from ombuds, for example, and other tribunals that are speedy and effective in the resolution of complaints, and that perhaps we need to think about whether one of those might be something worth learning from for the kind of mechanisms that we want to anticipate. So let's look at the first one, looking at claims of unfair discrimination of dispute. Okay. So in relation to protection against prohibition of discrimination, which is something that the Equality Act, the Promotion of Equality and Prohibition of Unfair Discrimination Act from 2000 already has in place for the large part, a specific clause that looks at discrimination against persons with disability or on the basis of disability. But this bill seeks to provide some illustrative examples as well. It says that to deny persons with disabilities reasonable accommodation unless undue hardship justifies such denial, that's included. Another example comes from the respect for their physical and mental integrity, healthcare, health services, liberty and security of the person, and to due process and not to be deprived of their liberty unlawfully, arbitrarily, or because of their disability. If you do that, that is discrimination. And then another example from the long list, deprivation or arbitrarily depriving a person based on their disability of their right to liberty of movement and their freedom to choose their residence on an equal basis with others. So I'm just cherry picking a couple of examples here for you. So if you look at the last two clauses relating to liberty and security of the person, they are really important additions to this open-ended list, because it seemingly clarifies and identifies that involuntary institutionalization of persons with disabilities and limitations on their rights to liberty and freedom of movement, as well as their choice of their home, is going to be considered discrimination. But the challenge is that the bill obfuscates in a way the process of bringing unfair discrimination complaints before courts. And it places a potential procedural obstacle before persons with disabilities in resolving these disputes, which is not placed before persons without disabilities in seeking to lodge their discrimination claims. So if you are a person with a sex discrimination claim, you would not have to follow the same process. You would have a separate process under the Equality Act. If you're a person who is a complainant on race discrimination, again, you would follow through with the Equality Court process that is currently in place. Okay. So Clause 33 establishes a conflict administration unit, and its job would be to interpret, apply, and look at any other matter arising from this bill. Quite a tall order, okay. And what is concerning to me is that disputes would have to be referred to this unit in writing, okay? So what this does is it totally ignores the fact that many countries in the world have gone much further than the old school writing complaints that had to be brought. There are alternative ways in which we can bring complaints. We can do videos, we can do oral representations, and it seems to backtrack on the requirement that have been placed on clerks of the Equality Court to assist indigent, illiterate, or litigants that struggle with completing forms to bring their claims and complete the necessary forms to bring complaints before the Equality Court. So this particular encapsulation here, these requirements for how you bring a complaint, really is unimaginative and could be expanded quite dramatically. If a dispute is unresolved under the conflict unit, then you can, and it identifies a mediation option, which I'll talk about shortly, which theoretically is a good option, okay? But if you don't choose to go through this process, you can skip it altogether. Any party can decide rather to refer the matter straight to the Equality Court, and then the Equality Court's proceedings would then happen thereafter. So let's look at the impact of these provisions, all right? This is a unique dispute resolution mechanism that is premised on alternative dispute methods. It is intriguing because it may offer an adjudicatory environment which would be cheaper and quicker than a court process, because mediation, for example, often offers these kinds of advantages over adversarial or even inquisitorial options. And it may, again, in theory, be much more cognizant of the support, including the procedural and other needs of persons with disabilities, compared to the mainstream mechanisms that are available. And this is always the conundrum we face, of course. We want to ensure that mainstream organizations are accessible and inclusive, but at the same time, we recognize that sometimes specialization is highly desirable because we then ensure that we meet people's needs quickly and with the relevant expertise. So it's a little bit of a conundrum here that we would have to consider. But there's a choice offered to parties as a dispute as to which forum they would utilize. Would they first follow the mediation option under the conflict administration unit, or would they go straight to the Equality Court? Of course, we always like options. That's great. Okay. But that does create a little bit of uncertainty as to which way to go. And it may require amendments to the Equality Act and potentially their jurisdiction as well. But then it brings us to the question as to why this option is only made available to persons with disabilities. Alternative dispute resolution is not a new thing, but South Africa is quite late in the game in making sure that we take advantage of the advantages that they offer. But here we are identifying that it should only be made available to persons with disabilities. Okay. So yeah, that is something that we should consider its implications. Since the list of prohibitions under clause 27 is quite far-reaching, that illustrative list of discrimination examples, it's not clear whether the institutional makeup of a conflict administration unit may necessarily be fit for purpose for the entirety of the discrimination claims that might be brought before it. And of course, if we vest such a unit within the Department of Women, Youth and Persons with Disabilities, it may potentially compromise the ability of its staff to resolve disputes. And of course, we would identify that ideally conflict resolution should be a legal process because there are legal remedies that would be applicable, and therefore it might be more advisable to vest within the Department of Justice. Okay. Not mistaking or not forgetting that the Department of Women, Youth and Persons with Disabilities does have expertise in relation to disability and could offer that in a cross-sectoral way to the Department of Justice. This brings us under to the Equality Court, which currently acts under the Equality Act. And in theory, its processes are free and accessible, and legal representation is not a requirement, but you may be legally represented before them, and the magistrate plays an inquisitorial role. That means if a litigant is not legally represented, or perhaps as a person with a disability that might need extra supports and accommodations, the magistrate would then proactively assist that litigant through leading questions and interrogating the evidence that is before the court. But scholars and disability activists have critiqued the accessibility challenges facing the equality courts in South Africa, which includes geographical and attitudinal barriers. I see one of our participants here today, Dr. Rule, has written on this, and a very slow uptake of discrimination claims brought by persons with disabilities and their representatives before the equality courts. So the bill, instead then of trying to address and strengthen those accessibility and procedural accommodation challenges before the equality courts, leaves that forum unchanged, and those barriers may, in fact, remain in place. This brings us then to the second mechanism that is identified in the bill, and it identifies that there should be a review mechanism to the support that would be offered to persons when they exercise their legal capacity. Okay. So the Committee on the Rights of Persons with Disabilities clarified that the move from substituted decision-making to supported decision-making is a paradigm shift required by the CRPD and must be implemented urgently, requiring abolishment of current substituted decision-making systems. So Article 12 of the CRPD recognizes not only that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life, but establishes a duty on states to put in place appropriate measures to provide access to the support that they may require in exercising their legal capacity. Such measures to access support have to include appropriate and effective safeguards, like respecting the will and preferences of the person, and should be proportional and tailored to that person's circumstances, and so on. Importantly, it must also be subject to regular review to ensure that a competent, independent, and impartial authority or judicial body has oversight over those safeguards that are in place when those support options are offered. Now, with the aim of domesticating the CRPD, Clause 7 specifically tries to recognize the legal capacity of persons with disabilities and is finally our move towards supported decision-making. And this is really an important milestone for us to celebrate. And you can see the wording on the slide in front of you. Without going into any detail as to whether this provision adequately meets the requirements of Article 12, which it doesn't, but it's going a bit towards it, particularly because the word support is wholly absent from this particular provision. Our focus today is the mechanism which is provided here for measures relating to exercising legal capacity. Okay, so this bill identifies that either the South African Human Rights Commission or Equality Court would be the appropriate forums to review such support measures and to ensure that safeguards against undue influence and abuse are in fact in place. Okay. What that then is a departure from our current substituted processes that we have: curatorship, for example, administration of estates, and the mental health review boards in relation to mental health patients, okay, psychosocial disability. And of course, we know that support can be formal or informal, and that there's a whole range of them available to us. So this is really lacking in a lot of specificity as to what the jurisdiction would be in this regard. Okay. So who currently would review instances where people's legal capacity would be limited and where they would have to ensure that there are safeguards in place to protect their rights? We're talking about mental health review boards who review involuntary admission in health facilities. We're talking about the Master's Office of the High Court administering curatorships. And of course, appointments of curators are reviewable by the High Court. So the review by either the Human Rights Commission or the Equality Court, as I said, then departs from the current process. This is something that we carefully have to consider, remembering that the Human Rights Commission is an independent monitoring mechanism, right? So it acts as a Human Rights Commission, which is a national human rights institution with a whole range of functions and a mandate that is quite clear. And it is very likely that it will be identified as the independent monitoring mechanism under Article 4 of the CRPD that would be ensuring that there's monitoring of the implementation of the CRPD in South Africa as soon as this bill is in place as well. So its role then here as a review mechanism for support options is probably not the best option, and is something that we would have to consider in a bit more detail. What I also want to bring your attention to is that there's a clawback provision in the bill, which speaks to national legislation that should ensure the rights and responsibilities of persons with disabilities through guardianship, wardship, trusteeship, curatorship, and so on, must render appropriate assistance to persons with disabilities when they care for their children. Okay, so what this does is it conflates the requirement that appropriate assistance should be provided to adults with disabilities when they care for their children, okay? But it entrenches current substituted decision-making mechanisms like trusteeship or curatorship, and that is problematic. Our time really is coming to an end, so I'm just going to allude to the fact that the third mechanism available to us under the bill is that so-called Equal Opportunities Office, which its title is a bit of a misnomer because its function effectively is a referral mechanism. Okay, so it doesn't have teeth. There's no enforcement to check up or to monitor that those disputes are actually satisfactorily resolved by the various departments. So in conclusion, we have a whole range of mechanisms now identified in the bill, and we have to decide whether they are fit for purpose. Okay, if we consider the current landscape of courts and other forums, will these be effective? Will we maybe need to consider alternatives like a specialized disability tribunal? That's something to consider. And then, of course, what adaptations and removal of barriers will we need to have in place to ensure that our entire justice system is accessible, is easy to use, transparent, and puts in place effective mechanisms for persons with disabilities. All right, so our time is nearly up, but I'm hopeful that we now have an opportunity to invite at least one or two questions to be answered. Before we do that, because our time really is nearly up, I do want to take this opportunity to thank a number of stakeholders that made today possible. Thank you in particular to our panelists who gave us their insights, and if they could just show their videos so we can see them at this juncture. To Kurt Conning from our IT department for his support today. To Ms. Hazel Lange from Corporate Relations for putting together our colloquium and the invitations. And then, of course, our Chair, Janine Hicks, for the wonderful welcome. And then our participants who have stayed with us through a late afternoon. The recording will be made available for your purposes later on. So if you have 2 or 3 more minutes, let's see if there's a question or two that we can answer. All right. So from the Q&A session, I see that there are a number of questions, one relating to employment equity, one relating to criminal offences, and then one that asks, any of the panelists, do you think a passage of a specific bill exceptionalizes persons with disability as a distinctly vulnerable group from other protected groups, and does doing so reinforce the medicalization or medical model of disability? I think that's quite an important question. If there is anyone, Prof. Grobler du Plessis, is this a question you may want to answer?
I don't think that we are, if we are passing a bill, that we will medicalize this again. I think the crux here is, or the answer to this is, how the bill will ultimately define people with disabilities. And if there's also a clear sign from the draft bill that there is a movement away from the medical model, and also in the definition of disabled or persons with disabilities in the bill, I think that will be specifically the measure in which we can see it. But I think it is a target group that has to be protected. So we can't shy away and say because we are medicalizing the problem that we shouldn't actually reinforce it with disability legislation. I'm just going to stop there, otherwise we're going to have other participants as well.
I've just got one comment to that as well. I can see why that concern would arise, but I don't believe it needs to be one, because already children are given, rather than exceptionalization, specific attention because of vulnerability and exploitation issues. So of course are older people. So of course are mentally ill people. And it follows almost axiomatically and logically that persons with disabilities would be the next group, because there's now a convention about them. How else would one be able to domesticate the convention without a specific piece of legislation? So I see the concern, but I don't see the exceptionalization. And of course, the bill is designed to move from medicalization and the medical model or the pity model and all of those to the human rights model and the social model. So, no.
Thank you for those comments. Then to Advocate van Veenendaal, there's a comment from Professor Combrink. If unfair disability-based discrimination is dealt with as a criminal offence, this automatically means that the matter will fall within the purview of the National Prosecuting Authority. Aside from the fact that capacity would have to be built in the sector, she's concerned that this also means the complainant effectively becomes a state witness and is no longer a party to the criminal trial, which may be problematic as the proposed provision regarding the burden of proof found in clause 36 of the new bill.
I don't see that the reversal of the onus of proof should be a problem. Yes, it will fall with the NPA, but remember there's also the possibility of private prosecutions. As always, that is not ruled out. But the reversal of the onus has received comment in the Constitutional Court a few times. So this might, I foresee that this might possibly be taken to the Constitutional Court for a decision on that or for consideration. But in this regard, if you look at the requirement of saying to the person, he's got to prove it. I don't foresee that there's a problem in this instance. I really don't. No.
Just in relation to the observation around the word, I suppose, from a jurisprudence point of view, is criminalization. The thinking there was that some aspects, to use an academic concept, of nudge theory, Sunstein's nudge theory, needs to be done. Because if behavior hasn't changed thus far to people with disabilities as a result of the Equality Act, the Constitution, the Employment Equity Act, and all the other pieces of legislation, what logically and cognitively is then needed next to facilitate a behavior change when nothing else has? And of course, you revert, unfortunately, to forms of fine, yes, and criminalization if absolutely necessary. And on the onus aspect, with intellectual, cognitive, neurological, and Down's diagnoses, it's virtually impossible to place an onus of proof on the complainant in those cases because they won't be able to articulate what is necessary to prove their case. So one should be thinking, I think, here, not of an adversarial situation. One does need to, I think of inquisitorial systems, as in the French situation, where a person who, a legal practitioner maybe with a deep sensitivity to the issues, assisted maybe by a person skilled in child law or psychiatry, psychology, or neurology, would investigate from an inquisitorial point of view and decide on liability that way, rather than the blunt instrument of inquisitorial processes with a magistrate or a judge who, for many, this will be the first time they've ever encountered one of these cases ever. Thanks.
Thank you for those insights, Mr. Strassheim and Advocate van Veenendaal. Our time really is running out, so I'm going to just identify one or two more questions. So one question particularly to, let me see here, to Professor Clark, Pillar 5 of the White Paper on the Rights of Persons with Disabilities refers to reducing economic vulnerability, which requires students to be academically prepared for employment, and the Department of Higher Education has a strategic policy framework as well. Is there a framework that includes university students? What legislative framework supports preparing students for employment? I think that we could perhaps start with Dr. Nxumalo. Are you aware of any of those?
Thanks, Prof. No. I'm not aware of a specific legislation except for the general labor legislation that deals with employment. So there is no specific legislation that is designed to prepare university students, but there are various labor laws that deals with the employment of individual in general. Thank you.
Thank you so much, Dr. Nomalo. And then our last question here, let me just scroll down if you'll just indulge me for a moment longer. Then there is a comment here from Nal Boshoff, which says, I believe that community-based outreach services to persons with disabilities are essential to bridge the gap in service delivery caused by isolation, communication, and mobility barriers, that these services do not exist. And the concern is there isn't an appropriate government body able and willing to provide the service, so that a coordinated, responsive, and accountable service delivery hierarchy or organogram is not put in place. Without this interventional structure, does not believe that the rights of persons with disabilities could be upheld effectively. What needs to happen to ensure that community-based outreach services is addressed in the Act? How do we create an effective, holistically and responsive and accountable structure? Perhaps in relation to children with disabilities, Professor Clark, is there something you might want to say in that regard?
I'm just I think, that if one focuses specifically on the barriers that exist for children with disabilities, and that those barriers need to be, as far as possible, removed, then I think this is a very important point that has been raised, particularly in relation to children living in remote areas. I'm just going back to the question again. Appropriate communication mobility barriers. Yes, I think that often it's very difficult for people with transportation problems, etc., to get access to justice. And there I think that would be, communication strategies should be put into place. Don't know if I've answered that question. Is coordinated, responsive, and accountable service delivery is missing. I do agree with regard to children. There needs to be some body which is able to respond in that regard. Caused by isolation, communication, and mobility barriers. Absolutely. I'm not sure exactly how one would address that, but certainly that is a gap, and it's a very interesting gap that's been identified there. Thank you, Mr. Boshoff. Thank you.
Thank you, Professor Clark. I think it's really important that you've highlighted that there's such little regard for children's specific requirements in the bill. And in my presentation on access to justice, I did not mention, but it's pertinent, that children's access to justice requires particular measures for them to be age appropriately involved in this process. And it's not just the same as for any other children. There have to be concerted efforts to include them. So whether it's community-based service provision or facilitating them participating in access to justice, we really do need to think hard about how we're going to facilitate that and what concrete measures we need to be in place to do that. And our very last question this afternoon will come from Dr. Bongi Zengele, who's raised their hand. And I will ask you to please unmute yourself. And please be very brief in your question and identify who you want to answer. Zengele, are you able to unmute yourself? All right, then without further ado, Dr. Bongi, are you there? Thank you. You have the platform to speak, to raise your question.
No, sorry, ma'am. It's really was an error on my side. Thank you.
Not at all. Thank you so much for joining us today and staying until the bitter end. Ladies and gentlemen, our presentations will be made available to you, and we are very grateful for your time here. Please note that this was just a little taste on what the bill has to offer, and that we really encourage you to go and read the bill. If there are particular sections that you don't understand or need clarity on, reach out to members of this panel today or reach out to other individuals. Come together in a concerted way so we can ensure that the Law Reform Commission is made aware of all the pertinent submissions that they may need to have to ensure that this bill will be the best bill possible that can be put in place. There was one question in the chat box around the fiscus contribution. Where will the funding come from this? Well, it's very clear. The Western Cape Forum for Intellectual Disability, in that case, the High Court said, share the budget amongst all who are entitled to it. That doesn't mean that we need to put persons with disabilities at the end of the list. They are part of the list because they are part of everyone, and therefore the budgeting and the planning needs to be made as for everyone else, and this bill will require further allocations, and we are obligated under the CRPD to ensure that we do that. So we need to hold government accountable in that regard. And then I think there was a last question there. Where can you access the bill? You can go to the Law Reform Commission's website. The deadline is the 30th of April. Thank you so much for your attention, everybody. Goodbye. Take care. Salani kahle.